Good morning, everyone. People are already starting to come in. It's 8:05. We're about 10 minutes early. We have a lot to do this morning. We have a misdemeanor arraignments and lots of them. Windy and wet. I did ride my bike. I didn't see one human person or car. Did see a possum and a dead skunk. Let's see what you got.
I have Mr. Fox.
Oh, I'm sorry. You came all the way over here for that.
Well, I broke up the trip, so it's
I guess halfway. We'll see. Today is Juneteenth. That isn't always on the exact same day. Several years ago, the state Supreme Court made it a court holiday, which they did on short notice, and the county contracts didn't cover the day off. And so the next couple of years, I just closed court that day. Now we're just back to business as usual. I do enjoy my bike ride in the morning when there's nobody out there except a possum. Good morning, everybody. Thank you for being here on time. I'm Judge Middleton. I get to have my name right there. Some of you I've met, some I haven't. You're here for an arraignment. The arraignment is the process where the judge tells you what you're charged with and asks you how you wish to plead to the charge. You'll see how this goes as we start to go forward. This gentleman is the chief public defender. His name is Mr. Keith Stickley. The other gentleman is the city attorney for the city of Sturgis, Mr. Timothy George. Other people may come in and out as we're going through this. When I call your name, I want you to come right up to the podium right there. You will get your top copy of your advice of rights, and then we'll address your case. So it is 8:15. It's time to start. We'll turn the record on. And we'll start with Mr. Emanuel Lee Poole. Mr. Poole, would you come forward, please? Good morning, sir.
Good morning.
You got a ticket on May 30th, Lutz and Mintdale and Florence Township for driving with a suspended license. Plus you were going 70. So they stopped you for speeding and gave you a ticket for driving suspended.
Yes.
Your license is suspended. It says you don't have a license. You got a ticket in 2021 going 89 and you never paid it. So that's one of your problems.
That's
You don't have a license. That ticket that you got back in 2021 has never been paid. And you owe
I didn't realize.
$228 on that unpaid ticket. Now, they used to suspend your license for not paying tickets, which I fully agree with. But when the criminal justice reform statutes came out, they took that away. So they no longer suspend your license for either not paying a ticket or not showing up. You have two problems. One, you don't have a license. And two, you have an unpaid ticket. This is the middle of the day out in the country. Let me tell you what the charge entails. Driving suspended is a misdemeanor. It's one of our most common offenses. It's punishable by up to 93 days in jail and a fine of up to $500. Carries 2 points on your driving record and requires that your license be suspended. So you don't have a license. So I'm not sure driving suspended is the actual correct charge. Let's see what the ticket actually says. It's more like no ops ever acquired.
Yeah.
You have an ID.
I guess the ticket that he just mentioned.
What would you like to do with this, Mr. Poole?
We're gonna, if I might suggest, his license issues might be cleared up if he takes care of something in Indiana.
Yes.
So,
Oh,
I
you
might
also have
ask-
Indiana issues.
yeah, so I think a little bit of time, if he act quickly and diligently, would be a great benefit.
All right. Has unpaid ticket. Yeah, there's nothing in here that says you can't get a license. Also Indiana issues. I'm going to set a pretrial with a prosecutor for today's Juneteenth. Set it for July 10th. Also want you to pay your ticket. I'll just give you a notice. Apologize in advance. I don't have very good writing. That's the ticket you owe from 2021. When you were driving back to the future at 89 miles an hour. So you got defaulted. You never answered it and it got defaulted and then it's just been sitting there. So you need to clear that up. And that'll help your situation with the prosecutor, and anything you can do to move forward with getting your license, bring that information with you too. You're not missing work, you're missing sleep, but we'll see you on July 10th. All right, you're good to go, sir.
Thank you.
Thank you. Got some more customers, a little late. We'll wait a little bit, Mr. George, but it doesn't look like your customer's gonna show up again, which is about par for the course. Brendan Keio, one of these is ordinance. One of them is state statute. You're Brendan
Yeah,
Peck Keio?
sure.
How do you say your middle name?
Eight.
Pig? Pig. All right, you got a ticket on May 25th for driving without any insurance and improper registration plate. Driving with no insurance is a misdemeanor. It's punishable by up to a year in jail, fine of up to $500 and not less than $200. And no registration plate is $120. Those often go hand in hand if you don't have insurance because you don't have a proper registration. Then you like that so much, you got a ticket a couple days later on June 13th for driving with no valid operator's license. So let's take a look at this because they didn't charge you with no ops in the May ticket. So yeah, you don't have a license. Well, they didn't charge you with that. On the first instance, they just charged you with no insurance and no registration. The second instance wasn't actually set for today,
No,
but I had them move it ahead because you're here anyway. They didn't put it in my queue. Darn it. Maybe I'm just, no, there it is. I apologize. Yeah, you had an arraignment set next week and you're going to be here anyway.
Mhm.
That ticket from June 13th is driving without a valid license. That's a misdemeanor, punishable by up to 90 days in jail, fine of up to $100 and 2 points. You were in Three Rivers at 8 o'clock at night. All right, to further complicate things, you drove here today without a valid driver's license.
No choice.
Well, I'll give you a choice. You could go sit back in a cell. What's the deal with your Indiana license?
So I don't even know why it got suspended in the first place, because it said when I called that I didn't pay my ticket, but I did pay my ticket.
So you may have an unpaid ticket in Indiana?
No, it was for my very first ticket. It was a speeding ticket, and it got paid. I got pulled over a second time, and that's when I got this ticket that we're here for. And they didn't tell me that I had a suspended license.
Well,
then.
it's not suspended. You just don't have one. Now, if you had an Indiana license and it's gone, it should be charged perhaps as 257904A, no ops ever acquired. But they charge it just as no valid operator's license. That's different than driving suspended. No valid operator's license is a misdemeanor. It's punishable by up to 90 days in jail, a fine of up to $100 and 2 points. But it doesn't require a suspension. You obviously are taking this very seriously. You get a ticket May 25th, you get a ticket June 13th, and you drive to court with your license being not valid, not having one. And I don't make the rules. They say you have to have a license in the state of Michigan to drive a car on a public highway. You have a different view of it. Do you have insurance now?
Yeah,
Who's your insurance carrier?
Progressive,
And is the vehicle properly registered?
yes,
Whose name is it in?
mine.
I'm surprised they'd give you insurance if you don't have a valid license. What's the status of your license? You don't know?
I have a license, but it said it was suspended.
All right, well, the other problem is you live in Michigan and you have an Indiana license. How long have you lived in Michigan?
Couple months now,
All right, who lives on Long Necker Road?
my grandma,
What's her name?
Deborah Franks.
Okay. Long Neck Road is officially not on the way to anywhere else, but what do you do, sir? What's your occupation?
I work over at Morgan Olson.
So you gotta get back. I suspect you drive to work every day.
Yeah,
What shift are you on?
first,
So you're missing work now?
yeah,
Well, one of these is an ordinance case. Mr. George is here by happenstance. I set it for today so you wouldn't have to miss another day of work because you were already here. So you got no operator's license and you have no operator's license. You have no insurance, but now you have insurance. You have improper registration. Now you have proper registration. You drove here. You're gonna drive to work tomorrow and the next day and the next day. And what you need to do is go to Indiana, not call them on the telephone. Find out what you need to do to get your license straightened out.
I actually did.
Okay,
So I had to apply for an SR22, and they said after like 180 days, the suspension would be lifted, but I'd be okay to drive with it.
let me see what you got.
I don't have that paper with
Oh.
me, but I can pull it up on my phone.
Mr. Stickley, you got any thought here?
I know it's inconvenient for work or whatever, but it would be handy if you can, at least in the, he's not gonna get a Michigan license till he clears up Indiana, so a couple, 3 weeks would probably be very beneficial.
It would be. Now, the prosecutor will give him some consideration because he has valid insurance. Mr. George, doesn't know what the deal is with the ordinance case. So I don't want to, I want to split this up.
I think we should keep it together, Your Honor, give him 21 days.
All right, well, I'm not gonna go to July 10th because it makes Mr. George come here on a day he's not here, so I'll set it for a Tuesday. Now, what I want you to do is bring some paperwork from Indiana that shows what the deal is. Either come in with a valid Indiana license or start the process to get a Michigan license. Now, if you're suspended, I can't tell from what I'm looking at, the Michigan driving record shows you that address Calhoun Street was Fort Wayne, not Three Rivers.
Yeah,
I'm interested to know what you were doing and where you were going, but I'm not allowed to ask that at this point. This was in a car, not a motorcycle.
yeah.
Set. It is inconvenient. I don't want you to get pointed out at work.
I already let my boss know that I was gonna be here.
All right, I'm gonna set a pretrial. I'm gonna set it on a Every day is just as bad as every other day.
They'll work with me if you can put it as any date.
I'm gonna set it for July 14th at 8:30. Well, we're off by the herd of turtles. We've had 2 cases and no progress. Tuesday, July 15th. I would put it on the 16th, but I'm using that day for some other stuff. Bring license and insurance. All right, let's talk about some else. You can drive home from here if you'd like to. In which case you'll get pulled over by the police between here and your house, and they'll impound your car and give you a new ticket for driving without a valid operator's license. So one option is to lock you up. The other option is to have you call somebody to come get you. I don't want you to get another no ops ticket, which you're probably gonna do because you're gonna drive back and forth to work anyway. If you're not driving away from the courthouse, you gotta call somebody to come get you. So I'll see you on July 10th and have somebody bring you. We got both the city attorney and the prosecutor dealing with this. You're not in a hole you can't dig out of. I've got lots of people who can't get a valid license for one reason or another. Too many drunk drivings. They don't have lawful residency status. Other reasons. This can be fixed unless you step on a few more landmines. So try not to do that. We'll see if we can get to the point where you're valid either in Michigan or Indiana. Did he get printed?
Yes, sir.
All right, the insurance charge requires it should be fingerprinted because it's punishable by up to a year in jail. Now that you have valid insurance, the prosecutor will probably be willing to reduce that to a civil infraction. The problem is, I'm not sure how you got insurance without having a valid license and registration.
I got it the day of when I got pulled over, like not even 2 hours later, I got my insurance.
All right, well, I'm glad about that, and I'm happy you got it. I'm not sure how you got it without having a valid license.
I reopened my old insurance. I'm not sure.
All right, well, again, this problem could get fixed as long as you don't keep doing this. But you're gonna need grace from the county prosecutor and the city attorney to get there. Anyway, you go call somebody to come get you. I'll see you on July 14th at 8:30.
What do you want me to do with the ticket?
What?
What do you want me to do with the ticket? Do I pay it?
No, don't pay anything yet.
Okay.
And you had another appearance date
Yeah, next
week.
Tuesday.
I just took care of it today.
Okay.
So you don't have to come back for that.
July 14th.
July 14th. I gave it to you in there.
Yeah, come back to this day, don't come back this one.
All right, you're good to go. Hopefully somebody come pick you up.
Okay.
All right, we'll keep plugging away here. Mr. George, I'm not gonna make you wait anymore. And I'll have a chance that John Fox will show up. Matthew Slavings. Good morning, sir. Are you Matthew Logan Slavings?
Yes, sir.
Mr. Slavings, you got charged in file 25932 SM with no insurance and unregistered vehicle, same charges as the last guy. You have an unpaid speeding ticket that might be part of this same thing. Let me look at it. Oh, that's the last dude. My hair was supposed to look like his, but it never did. His is a lot better than mine. He's also about 50 years younger than I am, but mine never quite worked out. Like Troy Polamalu. You got a ticket for driving without insurance, unregistered vehicle out on Stolt Road at Canoe Road, which is by the Pleasant Lake Public Access. Driver stated no insurance. Were you going fishing?
No, I was actually hauling a trailer, full of brush from work. That's what the no registration's for. He hit me with that for a trailer.
All right, but it was a work trailer?
Yeah,
All right, let's take a look at your ticket, that speeding ticket. Where do you work?
Aspen, tree experts.
Were you driving an Aspen truck?
No, this was for my company.
Okay. Keith, I got a couple bench warrants too. Shayna likes to give me those each morning. Where's the speeding ticket?
The speeding ticket was on
No,
131.
okay, it's a different deal.
Yep, different deal.
All right, let me find it. Yes,
Do you want me to take these?
yeah, please. I got three now.
Well, two of them are for the same person.
Okay. All right, you got that ticket. 60 and a 55, pretty minor ticket. And the date of that ticket was May. Oops, darn it. May 26th. All right, now let's get down to this case. Do you have insurance and registration now?
Yes, I have the registration paperwork with me and the insurance, the copy of proof of insurance is on my phone.
All right, why don't you show that to Mr. Stickler?
Okay, so the trailer was my grandpa's, so he got it registered. And it was MATTHEW.
Your ticket is,
SLAVS.
well, it doesn't, it's not late yet.
No, I was told I had till the 24th of this month.
Yeah, you do. You can't get much more of a minor ticket than 60 and a 55. I don't know anybody in the world that hasn't driven 60 and a 55, including Michelle. All right, Mr. Stickley's gonna take a minute here in a little bit and go talk to the prosecutor about your current circumstance. Let me repeat, if you didn't catch it, driving without insurance is a misdemeanor. It's punishable by up to a year in jail. It carries a minimum fine of $200 and a maximum fine of $500. And it requires that you get fingerprinted. No registration is a misdemeanor, punishable by up to 90 days in jail and a fine of up to $100. Really, what the prosecutor wants and the court is for everybody to get legal. So they'll often work with people and reduce the charge if they come in with valid insurance. There's a lesser charge known as no proof of insurance, which is a civil infraction. It's punishable by a fine only. And that fine is $150. So have a seat when we take a break here in a minute. Mr. Stickley will go catch up with the prosecutors doing the pre-trials and see what we're gonna do with those. People versus Pedro Daniel Guzman. That's you, sir?
Yes, sir.
You got a ticket for operating without a valid license, which is, used to be our most common offense till people started getting charged with no insurance. Did he show you that he has a license now?
No, Your Honor. So he does have a learner's permit. He's got an appointment on the 30th to get it wrapped up. So we'd be asking the court to enter a plea of not guilty today and then give him a little time after the 30th with a little luck and some parallel parking skills. He should be okay.
How old are you, sir?
23.
If you don't do all the driver stuff when you're in high school, the driver ed, phase 1, phase 2, phase 3, it's kind of hard to get caught up later on. So I get many adults, including young adults like you, that just didn't do it and didn't get a license. So you've started the process. So you got a permit and you need to take your driver test. Do you have it scheduled?
It's on the 30th.
On
of this
30th.
month.
I tell people, get one of those cars that automatically parallel parks, pull up, push the button and it'll park it, but some people, including me, are not very good parallel parkers. I have a long bed truck. So what we often do with these cases, Mr. Guzman, is adjourn them and let you come back in and show that you got your license. If this hits, if you get this no ops, it will ding you for at least 180 days. You won't be able to get a license, whether you pass the test or not.
I could have just 1 second. Your Honor, this gentleman is set to join the Marine Corps and go to basic training on July 8th.
All right, good for you. Well, let's accelerate things. We'll set this, your test is set for the 30th. Let's set this for July 1. And when you get in the Marine Corps, it'd be good to have a valid driver's license. Who knows, you might end up driving stuff. So will that work for you?
Yeah.
July 1st at 8:30. Marine license. Where are they gonna send you? Camp Pendleton?
Paris Island, South Carolina.
It's nice in South Carolina in July. Actually, South Carolina is very nice. Every time I've been there, I had a wonderful time, but I was never there in the middle of summer. That will be on a Thursday, oh, wait a minute, Tuesday. That's not a normal prosecutor day, but if you come in with it, Mr. Stickley can. Judge Patterson's gone that week, so I got double duty that morning, but we'll fit this in. Everybody's willing to join the Marines, it's all right with me. Pre-trial conference. 8:30, bring license. There's a lesser offense known as allowing another to violate the motor vehicle code. And if you come in with a valid license, it's very likely the prosecutor will offer that. And that won't go on your driving record, affect your ability to get your license. So I'll see you on July 1st. And hopefully you've got at least a slip that says you passed the test. And you'll be good to go. All right, thank you, sir. I'll see you on July 1st at 8:30.
Thank you.
All right, plugging away Christina Wheeler. Oh, this is an order to show cause. Are you Christina Joe Wheeler?
Your Honor, that's a yes and a no.
All right,
That is my maiden name.
okay. How do you like to be addressed?
Well, it's a Hartman now.
Christina Harmon?
This paper came to me in the mail, and this is not me. I had no idea what it was. We came here as soon as we got the mail and talked to the person. And she told me that I was arrested for destruction of property on May 12th.
Yes.
We haven't had a car, and so I can't go anywhere. And actually that day, it was a couple things besides crying because I didn't get to see my granddaughter on her 6th birthday. But I got a hold of a friend and I went to the store to get my mind off of that. Again, like I said, I've got
All right, so you're,
ID here. This is not me, and we need to fix this.
all right. Let's take a look at the whole background. I had a case, this has happened a number of times over the years. Sometimes a brother will impersonate their brother or a sister impersonate their sister.
Well, I just want to know if it was.
All right, well, here's the deal. The charge alleges that on April 13th of 2025, that you did maliciously destroy a truck window that belonged to Thomas Caldwell. The destruction was less than $200. And it is alleged that in the affidavit that they went to Keio Lane regarding a felonious assault. I was met by a subject next to a silver Dodge Ram pickup, said he was Thomas Caldwell. His girlfriend Christina Wheeler had a disagreement that morning and it led to his window being broken out. He stated he and Christina were in the front seat of his truck because they're homeless. They had an argument and you broke his window out. That's what the allegation is. Then you had a knife and they didn't charge that. So the allegation is that you broke a window belonging to Thomas Caldwell. Do you know a Thomas Caldwell?
No,
You've got an address of Hideaway Lane, Sturgis. Is that correct?
yeah, that's what's so confusing. I mean, the name, address is kind of right.
Well, I've also had a situation where people said, this wasn't me.
Right, I mean, I get
And then it
that.
was. There is no other Christina J. Wheeler in here.
If she was arrested, don't you have her picture?
I don't know that she was arrested. Let's take a
That's what
look.
they told me.
Yeah, we should. All right, so that person got arrested, posted bond, then did not show up for the arraignment. So rather than do a bench warrant, I did this order to show cause, and you came here today for the show cause. So thank you for that. Darn it. Christina Joe Wheeler, South Bend, DOB isn't in here. Yeah, DOB is the same as yours. I don't know. I can't tell if it's you or not. Mr. Stickley, why don't you come up and take a look? That's her, isn't it?
Really? I don't know.
I can't tell from the size of that picture. No tattoos,
I have tattoos.
none listed here.
She was booked in. I assume they printed her.
Yes,
Maybe we could get a set of prints and do it.
I'm looking for an actual lien, which would show that, but there's not a criminal history in here. I don't know. I can't tell from that little thumbnail of a picture. And the fingerprints should establish it, but she hasn't been printed. I hate when they arrest somebody and don't print them. She didn't get printed. Well, Miss Wheeler, I certainly don't want you to, a couple of problems. I don't know why they would arrest this lady. And she doesn't say, hey, I'm not Christina Wheeler. And there's a picture here, which could be you with longer hair. But it's such a small picture, I can't tell. And they didn't take your fingerprints, which is a sore point with me with the sheriff. When somebody gets booked in, they don't print them. I'm like, how do you know who they are? I think after all that, the safest thing to do is to get an attorney to assist you with this. If it isn't you, you have an absolute defense. You don't know Thomas Caldwell. This lady has the same name, same date of birth as you. Let's look at this. Same address. Where were you born?
Sturgis.
Well, this lady says she was born in South Bend. Says she
I
has-
have my birth certificate too. I mean, I've.
All right, and said she has 6 children.
I only have 5.
Oh, boy. Keith, you think it's worth presenting this to the prosecutor this morning? The problem is they're probably so overwhelmed with the.
I would go while she's here. I'd be happy to go chat with her.
All
while
right.
she's here.
Have a seat for a minute, and we'll have, I didn't bring the charge, the prosecutor did. And the police said it's you, this person said that was her name and date of birth and social security number.
You have the social security number?
Well, I don't want to.
Well, I'm just like,
They do have a social security number,
like, did she steal my identity completely or?
same social security number.
Great, somebody stole my ID. I gotta figure out how to fix that.
All right, have a seat. Every day has got something different and that's really different. When did you change your name to Harmon?
It's been almost 13 years.
Well, ma'am, stranger things have happened, and if we're gonna unscramble them, this is the time to try to do it. Good morning.
Good morning, sir.
You're Kiana Camille Nicole Holt.
Yes, sir.
You got charged with driving on a valid operator's license,
Yes, sir.
and you didn't show up. You showed up for your arraignment. You pled not guilty. I set up for a pretrial with the county prosecutor, and you didn't show up. Then you called and said you realized you missed court. So rather than do a bench warrant for your arrest, I did a order to show cause. So you're here, your mom brought you here, and I'm glad, rather than get arrested for this.
Yes, sir.
Have you done anything to get your license straightened out?
I have my permit. I got my permit renewed and I can take my test any day now. I just have to schedule it.
Very good. All right. The good news is I didn't enter a bench warrant for your arrest. I
Thank
figured
you,
your
sir.
mom would get you in here. And she did. And so I'm gonna do the same thing with you. Defendant has permit now. Plans to take test. When are you gonna take it?
The first week of June is when I was gonna schedule it, or July, first week of
All
July.
right, let's set this for pretrial for July 10th. Where are you doing your practicing?
Parking lots. My mom's been taking me to like the Walmart parking lots to practice. It's just my parallel parking.
Yeah, the
lots.
tricky, you heard me say it, I'm not too great at it
Yeah.
myself. But all right, let's hope you pass it. The prosecutor, same thing as Mr. Guzman, you come in with a valid license, the prosecutor should give you some consideration. How old are you?
18.
Well, it's nice to see you. I know your dad.
Yeah.
And your mom.
Yeah.
I think I told you that when I saw you the first time. Day of the week will be a Thursday, July 10th. All right, Miss Holt, let's hope you pass your parallel parking. Don't drive 89 and it's 55 like the other guy did earlier,
Of course.
and you should be okay. And hopefully you'll get that and the prosecutor will give you some consideration and then you can live happily ever after.
Yes, sir.
Okay, I'll see you on July 10th. We're gonna be
Great day.
busy that day. All right, let's take a break. Mr. Stickley's got his hands full with Miss Harmon's situation and try to figure that out possibly. That may be a reason why you sit here. Hi.
Josh has said the prosecutor's office will be around on the cases.
Oh, interesting. I'd still like to get to the bottom of it. All right, Miss Harmon. Miss Harmon, the prosecutor is going to dismiss your charge, which solves some of your problems. But if someone is out there with your social security number, your date of birth, similar appearance, I can't swear that it wasn't you in the picture that I saw. But if I were you, I'd go here to the jail and inquire. I'd like to have them compare your booking photo to the person that was there because a couple things, whoever this is still at large. But I'm not sure why Thomas Caldwell would just say it was you. All right, please raise your right hand. You swear or affirm anything you're about to tell me will be true to the best of your knowledge and belief?
Absolutely.
All right, so your testimony is that the person that allegedly did the malicious destruction of property on April 13th, 2025 is not you,
Yes, sir.
and that you don't know Thomas Caldwell,
No, sir.
and you weren't living with him in a truck.
No, sir.
And you never got booked into the jail.
No, sir.
What?
No, sir.
All right. I don't know what to make of this. You've lived at that Hideaway Lane address for a long time.
15 years.
All right. My recommendation would you go out to the jail, because at some point there's a record at the jail that you got arrested. There's a picture, which I frankly can't tell whether it's you or not. If I had a bigger picture, I could see it. In fact, I'll let you see it. And that picture ain't very good. Shows you had long hair. Did you recently get a haircut?
No, sir.
No.
Actually, it's recently been growing because I had it really short.
Anyway, this lady is apparently willing to be you. She didn't say, I'm not Christina Wheeler. And whoever this Caldwell is said it was you. So I'm confused. You have a birth certificate, says you're born in Sturgis. This lady says she was born in South Bend. Was your birthday 1975?
Yeah.
All right, case is dismissed. She was not fingerprinted here.
No, sir.
And the case is, I'd like to have one set of fingerprints on file, but if we print her, it's gonna go to that case.
Mhm.
So I'm not gonna order prints at this time. The case is dismissed.
Yes, sir.
But I would go out to the sheriff's department, see what you could confirm. All right, well, let's take care of our in custody people as long as I've got you, and I'm not sure what the status of those pre-trials is. Autumn Long is a retail fraud second degree. Casey Willis is a domestic violence and possession of cocaine.
See that come back a little bit.
What?
Starting to see this cocaine thing.
We
come back.
have, we certainly have. I hadn't seen cocaine for a long
The
time.
economy must be booming.
And we've
People
got
have
a
to-
guy who's pending trial in circuit court, had 53 grams of cocaine. Sweat had been working on him. And yeah, it wasn't a thing. I didn't see it for a long time.
53 grams, that's enough to share.
Yes, that's why he had a scale. People got better things to spend their money on than that. It's not quite as debilitating as some of the other things, but it's not the greatest. I really don't know what to make of that last lady. I'm gonna follow up on that further.
There are people around who claim they've seen her for a couple of years and that's what she looks like, so I have no idea.
Well, the other lady in the picture did look similar. She didn't have, her hair was longer, but it was such a poor picture that yesterday I was in this chair for like 3.5 hours. I got up and I was shaped like this. Good morning, ma'am. What's your name?
Casey Willis.
All right, Miss Willis, let me get your file. I'm Judge Middleton. And also with me is the distinguished Mr. Keith Stickley. He is the Chief Public Defender for St. Joseph County. Normally, we would do these in the afternoon, but a very busy afternoon and a very busy morning, but Mr. Stickley was here with me, so we thought we would address this now. You got two cases. First file is 24390 SM. That's a misdemeanor. In this case, it's alleged that on or about January 14th of 24, you did an assault upon Joan Gritzmacher, a resident of your household. That's charged as a domestic assault. You were arraigned on that charge, posted bond, and then you promptly didn't show up. Posted bond over the weekend, waiting on jail, failed to appear for arraignment. I did a show cause, and you failed to appear, and you got arrested last night, June 19th. How'd you get arrested last night?
I actually was picked up in Kalamazoo on Monday. And there was a hold for St. Joe.
Do you have a new Kalamazoo charge?
Yeah, I do.
What's that?
Possession.
Of which?
A narcotic under 25 grams.
So it'd be heroin or fentanyl?
Yeah.
All right. So you went off the grid on that one. That allegedly happened January 14th of 24. You already had a warrant out. On a charge of possession of cocaine. Let's take a look at that one. It might not actually be cocaine.
It's not.
In that case, the allegation is that on or about April 17th of 23, you possessed fentanyl as a second offender, making it a 8-year, as a habitual offender, making it a 16-year offense. You posted bond on that one and promptly never came back. You were in the Kalamazoo County Jail, and then we checked and you weren't in jail. You didn't show up and you got arrested last night. So I'm gonna set the bond. First of all, in the felony case, I'm going to show a plea of not guilty. I'm going to appoint an attorney. I'm going to set a pre-exam conference for July 1st at 8:30. And if a preliminary examination is needed, it'll be July 8th at 1. The original bond was $7,500 PR and you failed to appear. I'm going to set bond at $7,500 cash or surety with the following conditions: no drugs and no alcohol, no weapons, no assaultive behavior, and that's it. Are you on probation or parole in Kalamazoo or just bond?
Just bond.
Do you have charges anywhere else?
No.
On this domestic violence charge, you got arrested actually on both of these at the same time and then promptly didn't appear on either one. On the DV case, I'm going to show.
I had a heart attack the day of my court hearing, and he passed away this past March. But that is why I missed my court. I'm typically not a flight risk.
All right. We have a Dorset Street address in Portage. Is that correct?
Correct. It's my mom's address.
Who is Joan Gritzmacher?
It's my ex's mother.
All right. Appoint an attorney, set attorney pretrial for 7/1/25. Bond on that case was set at $2,000. PR will now set it at $2,000 cash or surety. To say you're not a flight risk is not accurate. You didn't show up on the cocaine charge, then you got arrested on both charges. You didn't show up, excuse me, on the domestic violence charge. You got arrested in June on the fentanyl charge and the DV, and then you probably failed to appear for both of those. You've been AWOL for 2 years. We're here all day, every day. All you had to do is contact us. And you get arrested on a new fentanyl charge. Are you going through withdrawal right now?
Yes, sir.
All right, I'm sorry, that's pretty rough. I'll talk to the jail services, but right now you're in a safe, clean place. I will see you on July 1st at 8:30 and we'll get an attorney to come see you. If you do post the bond, you need to contact your lawyer. Otherwise, your lawyer is going to come see you at the jail.
Okay.
All right,
thank you.
Ms. Wells, you're good to go. Thank you, Keith, for agreeing to do these this morning.
I thought you had another one.
I do. Bottom long, a retail fraud. I prefer to do these in the morning when I've got you here. A, it's better for the defendant. If I'm gonna give him a bond, we do it in the morning rather than late afternoon. And B, we don't have to scramble around, but I've got a bunch of final pre-trials this afternoon. We couldn't sell last Thursday and this Thursday's back.
Let you log on the jail, sorry.
Good morning.
Good morning.
You wrapped that up like you know what you were doing. This is Judge Middleton. I'm here at the courthouse. Are you Autumn Ray Long?
I am, yes.
Ms. Long, you have an old retail fraud charge. The allegation is that on November 16th of 2022, you were at the Menard store with a co-defendant and stole more than $200 worth of stuff. Let's go specifically into it.
Okay.
Alleges that a co-defendant named James Anthony and you were in the Menard store in Three Rivers and stole property worth more than 200 but less than 1,000. That's a misdemeanor. It's punishable by up to a year in jail and fine of up to $1,000. They have video of this. We don't get a lot of cases from Menards, but some. Actually called the state police tech. Yes, it's outside the city limits. And they advise that you and James Anthony were, and they observed you on video removing multiple items from the store and putting them in your purse. James was using a scooter. They did inventory of the stuff you took and it was worth $100. So that was the charge. You got arrested and they set an arraignment. You posted a bond in the amount of $300 cash or surety and were given an arraignment date of August 28th of 23. You didn't show up. So I did a show cause to give you another chance to come September 14th. You didn't show up for that. So at that point in September of 23, almost a year after the fact, we issued another warrant for your arrest and forfeited your bond that you had posted. And you apparently got arrested last night.
Yes.
How'd you get arrested yesterday?
I was walking down the street and, I had a warrant. That's what I was arrested for, was for my warrant.
This warrant?
Yes.
All right, where were you walking?
Montville.
Who stopped you? The state police?
No, the county did. I'm not sure what his name is.
What time was that?
Maybe 2, 3 o'clock in the afternoon, I think.
You knew you had a warrant. And don't give me your street address, but where do you live right now?
In Sturgis,
At the Prospect Street address?
that is correct.
Do you actually live there or just use it as a mail address?
Well, it's my dad's house. I was living there. Right now I was staying with a boyfriend in Montville, but I don't live in Montville.
All right. What's his name?
Anthony Montgomery.
So it's the same guy. Let's see what happened to him.
No, the Anthony Montgomery, is not who the charges were with from Menards. That was
That's
James
James
Anthony.
Anthony. All right.
Correct.
Who's he to Anthony?
I'm sorry.
Who are they related?
No, not at all.
Right. James Montgomery.
No, James Anthony is the one from Menards, and Anthony Montgomery is who I'm dating.
All right. Sorry about that.
It's okay.
Well, he pled, he got arrested. And the prosecutor dismissed his charge. Don't know why. What happened to him?
Anthony Montgomery?
Yes.
I'm not sure. We were both
No.
arrested yesterday.
No, James Anthony. What happened to him?
I haven't talked to him in years. I have no idea. I know he went to prison for something else, but I'm
I
not
think
sure.
I think that's why he went to prison. That's why he got dismissed. All
But I
right,
know
so
that
the
when
question is, what do I do with you?
I know
You
that when
blow off this thing. You wait around for 2 years to get arrested. I gave you 2 chances to come. You forfeited a $300 bond. Are you employed?
I am, yes.
Where do you work?
I clean houses and I help an elderly lady shower 3 times a week, and I clean her house and I do her yard work and stuff. I work Monday, Wednesdays, and Fridays.
All right, if I give you a bond, will you show up?
Yes, sir.
Or otherwise, I can set your bond at about $10 million and you can stay in jail till the next pretrial date. I'm very disappointed in this, that you just blew it off twice and then just waited to get arrested. I'd like to inquire more about it, but I'm not going to. So you're local, you're sort of employed, you don't have any other charges. That's the kind of case I'm supposed to set a PR bond on, even though I'm not very happy that you blew me off twice. I'm gonna appoint an attorney. Will somebody come get you from the jail?
Yes.
I want you to come directly from the jail to the courthouse. I mean,
Okay.
yeah, and report to the district court.
Okay.
I'm gonna set an attorney pretrial for July 11th at 8:30. I got about 85 cases set that day. I'm gonna set your bond at $500 PR. And if you don't show up, I'll set it at about $5 million PR. This is not the world's most serious crime. You need to address this rather than just ignoring it. And then what happens is you get just pulled over one day and you go to jail. So will you promise me that you'll show up on July 11th?
Yes, sir.
And you'll come directly here to the courthouse and get your paperwork?
Yes, sir.
All right.
Thank you.
All right, I'll see you on July 10th with about 100 other people. Josh,
So today I come straight to the
July
courthouse.
11th, Friday. What's that?
When I get released today, I come straight to the courthouse today to get paperwork and then come back July 11th.
Yes, I'm gonna set bond conditions, no drugs or alcohol, not enter Menards.
Okay.
What did your boyfriend get arrested for yesterday?
I'm not sure. They wouldn't tell either one of our charges in front of each other. Mine, I found out yesterday when I was on my way here.
Well, you must have known what it was, but we'll see.
Yeah, I knew that I had a show cause, but I wasn't sure what his are.
All right, I'll see you on July 10th, 11th, Friday the 11th.
All right. Thank you,
Okay.
sir.
Thank you.
Michaela Moaning, is she in custody or?
She's on bond. She's on.
The sentencing today?
Yes, sir.
Okay. All right. Earlier in this case, the defendant entered a plea of guilty to aggravated assault, a second-degree felony, and a pre-sentence report has been prepared. Have the parties had an opportunity to review it? And are there any corrections or changes to it?
Judge, I've received and reviewed it, and we don't have any changes from the first judge.
And state.
Same, Your Honor.
All right, it will be made part of the record for all purposes. And the agreement here is a cap of 10 years imprisonment. So we are looking at two options on the second-degree felony. No less than 2 nor more than 10 years confinement in prison. Also, the defendant could be placed on deferred or unadjudicated probation.
Yes,
I don't believe regular probation
Is
an option under law because of the circumstances of this case. All right. Mr. Lewis, you may go forward.
Judge, this situation, fortunately, it wasn't worse than what it was. Definitely. But it was a situation where my client has been dealing with some harassment and bullying, dealing with the complaining, her friends for a long time at this period. This confrontation here is pretty much her breaking point at that moment. It was totally out of character for her. Not something that, in normal regular circumstances, she would have acted in that way in any way. It was a situation where, and when I say prior bullying and harassing information, I'm talking about from people coming, breaking or shooting in the windows at her home to, very severe or serious circumstances, is that these things have been going on and actually have been even still dealing with some of it after this case happened, while she's been on bond, to the point of people associated with the complainant or either screen recording or whatever, sometimes Docket, and would post these things on social media in an effort to taunt her while this case has been going on. And there was even a situation where she's had people try to confront her. Now, I will say my client and her actions since then, she's done everything she can on her end to try to avoid these situations at all costs. She had moved to a new location that is a safe place for her and her child. That's undisclosed as far as she knows, as far as people associated with the complainant. She haven't had any issues while she's on bond as far as attending court or doing anything of that nature, other than I believe she had one situation where when she was in the hospital having a child, she had to miss court, but they had medical issues at that time. She has a 4-month-old child this time to raise and take care of. And as you see in the PSI, she has, until the pregnancy, maintained a stable work history. as well as going to school to help try to further her career. So she is making positive changes for herself, or I won't even say changes, staying on that same track. So I believe her future is one that's definitely salvageable in this circumstance. I think there's plenty of vehicles available through the probation department that could help Ms. Moaning as far as move forward, as well as still be able to um, serve out any punishment or sentence that court deems necessary. There, I know there's restitution involved in this case that my client, through with her schooling and her career moving forward, I think she'll be able to take care of that and do what she can to make the plaintiff whole in that circumstance. There are other conditions, of course, that's available to the court, as well as county jail time or anything of that nature to satisfy any concern the court may have of her actually serving some time in jail if necessary. And I know as far as her version of everything, she talks about, concerning the car running her over or running them over. If the evidence doesn't totally support that, but of course, what she may have been thinking of going through some of her friends, at that time could have been it, but maybe not enough to rise to the self-defense claim that she could have maybe used that trial, liable to use that trial. So we are asking that the court seriously consider placing her on deferred adjudication. I think she's the type of candidate that will be able to make the most of that circumstance and be able to be successful and move forward. Also, I would like to, she did want me to let the court know she wanted the opportunity to address the court and let you know how she would, her plans for the future, as well as her being able to be, how she feels for it being able to be successful on the deferred judge.
Yeah.
I just want to let the court know that I take full accountability of what happened today. And I am very, I changed my life all the way around. I don't hang around the same people. I have a child now. I'm in school. Everything around me is positive now.
Did you have a child then on March 30th?
Yeah.
You didn't have any, were you pregnant then?
No, I got pregnant after.
Okay, go ahead.
And it was out in a kind of a hard situation, but I take full accountability everything that happened that day. I wish everything was different. And I wish I could take it back, but it's you can't take it back. It happened. And I take accountability of what happened.
What caused you to act this way?
I want to say I was just at a breaking point, really, to the point where it was so much that happened to me, with these people. So it's a breaking point thing. And I was kind of in the fear of my life, and they probably was in the fear of their life as well, too.
How were you in the fear of your life? Can you explain that? Because only one person was shot more than once, right?
At the time,
It was you doing the shooting.
When it was going on, before the shooting happened, she was kind of in her vehicle trying to run me over. It was a thing like that. So I was basically not defending myself, but at the same time, trying to protect myself and who I was with. And basically, I guess she was trying to protect herself and who she was with.
Okay. The police came out and investigated this, didn't they?
Mm-hmm.
Okay. So after their investigation, did they charge the other people with attempting to harm you in some way, attempting to kill you, or attempting to assault you with their car? No? Is that no?
No.
You have to speak out.
No, sir.
Why do you think that? Or did the police fail in their job, or do you think they investigated this thoroughly?
In my opinion,
Mm-hmm.
I really don't think that it was, because when they called me, I was actually I was out of town when they called me. But I told them when I came, when I was coming back, and they were supposed to came out and fully investigate with me to take my side on what happened that day, and they didn't.
Well, they investigated it and they did not elect to file charges against the other people who you say were attempting to harm or kill you
Mhm.
with a car.
Correct.
And you were defending yourself. Self-defense. That's what it seems that you're saying here. You're not admitting, you're saying that they were trying to harm you and you were defending yourself by protecting yourself with a firearm and shot somebody 3 times, right?
Yes, sir.
The right shoulder blade, left ankle, left forearm, and upper lip, sorry, 4 times. But upon their investigation of this, they did not charge the other people with anything victimizing you, just you,
Correct.
which this leads anybody reading this to believe, according to their investigation, you just lost your composure and decided to use a file, which was the wrong thing to do.
Was.
Well, you got to pay a price.
Hmm.
Okay, well, too many people come in here and there's always somebody else's fault, and
And I was.
you're taking responsibility for your actions,
Correct.
but you have a lot to lose here. This could have been up to 20 years in prison. You understand that? And you got a a child,
Right.
and that you got to take care of, and a family that's, I guess, you're growing, and and you don't have a criminal history.
No.
Look, this isn't the first time somebody is before this court charged with a serious crime who believed that a lot of it had to do with being provoked. But yet, words, uh, threats, those things are just under the law aren't enough to get in a car, get a gun and shoot somebody 4 times. And the situation about you were defending yourself, truly, Mr. Lewis is a very wise man and he evaluates cases. And if he felt like there was something really to substantiate that, we would be having a trial like we have 600 trials in this court. I mean, we try cases and we're not afraid to try cases to get the facts out, get the truth, get responsibility placed on the people who justly deserve the responsibility. And this is one of those things where I believe we have a misunderstanding, to say the least. But you got to have the strength of character just to move on and be the better person. Because what happened is at the worst, at the best for you, is they dragged you down to their level, and then you pulled a gun, and then you get in trouble. But once again, nothing shows that there's nothing here that reflects you had to use that firearm to defend yourself. You were in imminent danger of death or serious bodily injury from being run over by a car. Nothing shows that. And if it were, we'd be here trying this case, and that would be a defense. But you accepted responsibility under these terms, under this set of circumstances, and there are no objections in this pre-sentence report?
No, sir.
Okay, and it's made a part of the record for all purposes. What says the state?
Judge, I do note one error in the PSI. When you look underneath the adult felony court history, the deadly conduct, which I am dismissing as part of this plea agreement, comes from the same date and offense. For some reason, there's a different date there. So that needs to be corrected to where it's March 30th of 2024.
Okay, so it was this other charge arose, I guess this is 24 CR 1105.
Right,
this arose from the same episode?
Yes, sir.
So the agreement is that indictment is going to be, which is a third degree felony of deadly conduct, this charge of a firearm, that is going to be
dismissed, but that should be corrected for the purposes of the PSI and this particular false number, Judge.
Okay.
All right. So, second matter. I'm really shocked that no statements come from Miss Ford, the victim in this matter. I've had constant contact with her since the beginning of this case. She is adamantly opposed to Miss Moaning receiving probation. That is a discussion that Mr. Lewis and I had while we were negotiating the resolution of this matter. Of course, what she wants is the maximum, and she's in opposition with me about the plea bargain agreement that was made. She's made that very vocal to our office, including my chief and emails and things of that nature, which is why I'm really shocked that that there aren't statements from her, and B, that she may not be present here today. That being said,
Okay, in the pre-sentence report that's been placed into evidence on that point, so the
Yes.
record is clear. Statements of interested persons, and the probation office is I always want as much information to make an informed choice. This states all attempts to contact the victim in this case have been unsuccessful. Any correspondence received prior to sentencing will be forwarded to the court as a memo, which it was not done. All attempts to contact law enforcement have been unsuccessful.
Yeah, I don't know
I've
whatever.
never seen that. This is odd. I've never seen a lack of response to the probation's office requests for information, but without it, this court, I know what you're saying about what the victim says, but when given an opportunity here where it needs to be, so the court can consider it, they refuse to talk.
So I'll be her voice because I do know what she has expressed to me. She is overwhelmingly disappointed in how this matter has been handled by law enforcement. She is adamant that Ms. Moaning not receive probation. She and I have visibly seen the injuries that she suffered. The PSI is correct that they are serious bodily injuries. It's very difficult for her to even travel. She is a Houston resident, and the timeframes that we've been able to meet, it's quite a struggle for Ms. Ford to even accomplish that. To say that when we deal with aggravated assaults with a deadly weapon, that we are merely inches or seconds away from dealing with a murder case.
Mhm.
I saw that when I saw the injuries that were apparent with Ms. Ford. So with that in mind, Judge, disappointed with the defendant's version, but Your Honor has already gone into the detail about that, so I won't highlight that. I will say that her lawyer is an excellent advocate. He has been working on this case throughout. Mr. Lewis brought to me. We're always on a first name basis, so I'll be professional and say Mr. Lewis brought me the arguments about the bullying. He brought me the evidence that he was tendered. I investigated those claims. I found no merit in it. Otherwise, you would see something different. It was only due to his advocacy that I capped the agreement at this to allow him to come into court to make the best argument for his client as far as the probation is concerned. But as I said, I'm disappointed with how she approaches this. She tries to appear as the victim, tries to minimize the situation here that was done. And it is not a situation that anybody in Beaumont would be proud about. The situation that occurs is a shooting that happens in the heart of the West End, right across from Parkdale Mall, at a time in which most people, much like a case we dealt with earlier in this courtroom, Judge, are at home and asleep. 1:30 in the morning, right outside of Fuma, Dubai. Just like she describes, this is more of a nightclub than anything else. And the criminal activity that takes place here with the amount of shootings and the injury that takes place is alarming to me. And that highlights what the probation office says, which is, as the defendant appeared to take responsibility for actions occurring that night, the violence that was inflicted upon the victim and the community is alarming. The defendant appeared to not take into consideration during the offense how innocent bystanders could have been harmed or killed from her actions. That's why the
No,
other
you said
case
the
was
victim,
filed.
the defendant.
I apologize. You're correct. The defendant appeared to not take into consideration during the offense how innocent bystanders could have been harmed or killed. Judge, these are the kind of things that with the DA's office, when guns are involved, shootings occur and near death almost happens, we cannot agree to probation. I can appreciate that she's never been in trouble before, but I don't think she appreciates that we almost lost someone due to her actions. Stand by the cap that was offered. I suggest 10 years.
Go ahead. Anything further, Mr. Lewis?
Well, Judge, just one thing I would like to add is that in Ms. Moaning's statement to the court, main reason she wanted even to do that was to make sure you understood that she was taking full responsibility for her actions. In no way she's trying to minimize what happened out there. She doesn't understand how severe that circumstance was. And that doesn't change my opinion that if given the opportunity, I believe she could definitely be successful on probation, especially with the track she was already on and what she could continue to do, especially in raising her child. This moment, especially now, is totally different where she has someone else, even beside herself, to totally live for and make decisions for. So I still stand by that and ask that the court consider deferred in the situation.
All right. The some circumstances are a lot more difficult than others that the court has to deal with, and this is an agreement, but it still gives the court options on how to proceed. Among other things, the court tries to set a standard on similar behavior, how people are going to be dealing with similar behavior upon rulings of the court when they are put in a situation. They may not be paying attention, but the ones who do go, somebody got in trouble and went to prison for this not long ago. I better not do this. If they're able to think coherently during the time. And nothing, if it were true that the defendant was was defending herself under the law, that should have been raised in a different setting, but it was not. It wasn't. And there are ways of dealing with self-defense as a defense, and it's not supported here. It does state, it doesn't say that, except for you, that somebody was trying to hit you with a vehicle and you were shooting to defend yourself from a vehicle that was being driven at you when you were just walking across the parking lot innocently. That's not in here. That's what you're saying, but it's not in this pre-sentence report that was prepared and is what the court can consider. What we do know is that this was a product of something that had earlier occurred that should have been dropped. It was something had happened before, and as they were leaving, and as the parties were leaving the club at 1:33 in the morning, where nothing really good happens, then you are shooting at this vehicle and the people in the vehicle, and somebody shot 4 times. Not just for that purpose, but this is a public place, and there are probably other cars, and you're lucky 3 or 4 people didn't get shot by wild shots. It's just you can't handle issues like this in a way that is irresponsible. And what are you doing? Well, this was a club, right?
Yes, sir.
What are you doing it sells liquor?
Yes.
What are you doing in there with a gun? What are you doing in there with a firearm anyway? That shouldn't even be in there. This was very poor choices, and you're lucky that this person who was shot 4 times in the shoulder, left ankle, forearm, and upper lip. I don't know how that happened, that they weren't seriously injured. And others in the parking lot weren't injured. I mean, several people could have been harmed. We've got to, by our decisions and what goes on in this court, set standard for everyone. This, Mr. Lewis is asking for probation, and it's an option in this particular situation, but it's these circumstances that this court has a lot of problems with in believing that probation and deferred or unadjudicated probation in this case is the way to go. I mean, it was multiple shots fired, and this why just God's will is. I mean, you were intending to shoot this person. God's will prevented a murder from happening, where you would be looking at up to life in prison. And messages have to be sent. You can't just go into a shooting spree in a public place, and people also get harmed, and people are in harm's way, and you're going to get a free ride out of that, and it's, as it were, and get probation. I mean, it's just all irresponsible from the beginning to the end on this. And the difficult thing is that you got a family at home that needs you, and the district attorney's office is asking for 10 years in prison. And if I hear a response. Anybody that responds while the court is talking will be held in contempt of court. I don't want that. That's 180 days in jail. Anybody want to say anything? The peace, be quiet. We're conducting business, or leave if you want to. You have freedom of speech. Go outside and speak, but don't interrupt this court. I can hear that. We all hear that. And she's taking this down, and what she hears as the court reporter, she takes down. And statements from the crowd don't count. Please follow the rules. Thank you. The court has to set an example. This is highly irresponsible. You shouldn't have had a firearm in the first place at that location. Anyway, I mean, that prevents you from losing your composure, which I think it's obvious you did. But when you shoot somebody 4 times, there's only one purpose, and that's to kill somebody. I mean, you don't shoot somebody 4 times and think, oh, I'm just going to wing them. That's not it. And one of them is a shot in the mouth as well. You're lucky. This is not a life imprisonment case. All right. Your attorney has minimized it to 10 years and up to 10 years in prison. What this court is going to do is these are more difficult. Some decisions up here are far more difficult than others, and this is one of those. The court is going to find that you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in your plea hearing to find you guilty beyond a reasonable doubt of this second-degree felony of aggravated assault with a deadly weapon. I now find you guilty beyond a reasonable doubt of this second-degree felony of aggravated assault with a deadly weapon. I'm following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. And the judgment shall reflect that a deadly weapon, namely a firearm, was used in the commission of this crime. Do you understand what has happened today, May? All right. You and others must make wiser choices when there's a firearm and there is a situation where people can lose their composure. You're lucky that it wasn't a murder case, but you can't be firing a weapon numerous times at a public place and not be held responsible. And there's nothing here that supports anything in this report, nothing that shows you were acting in self-defense or that there was a need for it. That's the order of the court. This other case is
I've sent the dismissal.
dismissed. Thank you. That is all. I need a pen. This.
Yes.
JW Marshall. All right, in 24 CR 2449, you were JW Marshall, present with your attorney, Mr. Burbank, and the state's attorney. Mr. Burbank is your attorney, correct? Yes, sir. He's filed a bunch of motions on your behalf. And, okay, these things that you're filing, the court doesn't accept that. You have a lawyer. This is what's called hybrid representation, which is disallowed under the law. You've got to either trust your lawyer, you run this by him, then he'll do what needs to be done. But this is not things I'm going to consider because he's the lawyer of record. You have a right to be heard, of course, but you can't have two lawyers unless you pay for them. You and him can't do it at the same time. Yes, sir. He's been assigned. I don't know. Did you hire him?
No, I was.
Okay, you were appointed, and okay, you want to represent yourself. Anytime you want to do that, let me know, and that would be a bad choice. It's always been a bad decision, but some people are insistent, and it never works out well for the defendant. But that's been our experience in this room with 18 and a half years and 600 jury trials. We can figure out what's the right way and what's the wrong way. We've seen it so many times. But this is, when you send this, the court's not going to receive it because you have a lawyer and he's the one responsible for filing the motions and representing you. So you don't want to get into a spot of where, well, if you're going to be doing it, he's gone. See you. He's a wise man and he's a good lawyer. You got to trust, run it by him. He knows how to do it and what is the best way to represent a defendant. Okay? Yes. All right.
Your Honor, if I may, one of the motions that he did file was for a possible bond reduction. I did file an amended motion that I signed on for. The basis, if I may address the court.
Yes, sir.
Briefly,
Yes,
is that prior to the charge of murder being filed against him, he was out on bond. There are other cases in this file that he was taking care of, and he was on bond. He was compliant with all the rules and regulations, showing up to court, abiding by the rules and conditions. When this new offense came, then they, of course, put a new bond, raised the bond on the murder charge, and he's been in custody since then. He's asking for consideration of possibly reducing the bond down.
Okay, this in summary states the bond is presently at $1 million and you are asking on behalf of the defendant that the bond be reduced to an amount that the court determines is reasonable. I know what the background is on why this was done this way, but does the state have anything to add here?
Yes, Your Honor. The state obviously would object to any kind of bond reduction. The defendant has 4 prior felony convictions, so he is a habitual offender. And at least 2 of those are in sequence. Also, the nature of this crime, it's alleged that both the defendant and Jamal McCain, the co-defendant, gunned down the victim in this case, and it is on video. You can see 2 individuals gunning an unarmed victim down. and shooting him multiple times, both of the individuals doing that.
Anything you want to add, sir? You need to go? Okay. All right. A couple of decisions the court's going to make. Number one, this court is going to deny the motion for bond reduction. I've reviewed your criminal history. I have reviewed the circumstances of the offense. Those are the key determiners in determining what a bond is under law. Number one, murder. Yeah, that is the most aggravated and violent crime unless it's multiple murder. Number two, you, according to this indictment, have at least 4 prior felony convictions that dating back 24 years. And not the least of which is a conviction of robbery in 2007, which is a violent crime. The others are, it looks like illegal possessions of controlled substances, which are felonies. So this, if true, constitutes a habitual offender. Your punishment range is no less than 25, no more than life years in prison. And that's as serious as it gets. So this is number one, a serious felony of murder, a most serious felony. It's the use of a firearm. Somebody is killed. It's a violent crime. You have multiple felony convictions, including another violent crime. And in reviewing the probable cause affidavit, this court finds that $1 million in bond is most reasonable under the circumstances of the case and your rich criminal history. So we're going to set this for trial.
We ask that it be said as soon as possible.
All right, y'all, what do y'all need to do to get ready? Because I'm going to try to accelerate this, please.
Your Honor, won't take much. I think the co-defendant is currently set for October. So
anything can happen in a case. I
think we'd prefer to go on the co-defendant first in October. I think that's when we're set to go on that one. We got everything ready. Mr. Marshall was arrested after this, after we received some additional information.
Lacey, I need this set right after the co-defendant's case.
Yes, sir.
Okay, we'll get it. Please
Yeah,
note it. And
file real quick and then
All
I'll
right.
get them a date.
anything else on this?
No, Your Honor, we'll be excused.
Thank you.
for that.
That is all. Yes.
Maybe look at it again if we're not.
Yes, sir.
I can tell them
What's this?
them all.
Joshua Booker, Judge.
Yeah.
This was added on to yesterday.
Yes.
Okay, I don't think we got it on the print, but okay.
Yeah. Turn it back on without stopping the string.
Okay, do I have to file on Mr. Booker?
It's at the very bottom of the file. And then I'll need him to be brought out so I can think.
All right, Joshua Booker, please. We got dark over here.
Yeah, we turned off the webcam, Judge.
Why? For
It's-
him?
But for the victim impact.
Oh, on
You want
this
us to-
list.
well, I guess we can leave it on for
Yeah,
this and
listen.
then just.
We can leave it on for the plea and then,
Okay.
Mr. Booker. Please raise your right hand, sir. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
All right, we now call 23 CR 1490, the state of Texas versus Joshua Booker, who is present with his attorney, Mr. Wilkerson, and the state's attorney. Does the defendant waive a formal reading of this indictment here? Can we proceed in summary?
He does, Your Honor.
All right. In summary, Mr. Booker, this indictment alleges in paragraph 1 that on or about December 1st, 2021, in Jefferson County, Texas, you committed the first-degree felony of aggravated sexual assault of a child. Do you understand what you were charged with here?
Yes.
Okay. Because the child was younger than 14 years of age, this becomes it's referred to as a super aggravated first-degree felony, which means the punishment range is enhanced from not less than 5 to not less than 15 years imprisonment, up to 99 years imprisonment or life imprisonment. Do you understand the punishment range applicable? And I guess as well, a fine up to $10,000 could be assessed, but that's not going to be of consequence in this case, correct?
That's correct.
You understand what you're facing here, sir? Yes, the gas That's nice lady can hear you. All right. The agreement's been reached where you would be pleading guilty, sentenced to 45 years imprisonment. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand? How do you plead to this, guilty or not guilty, sir? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents true and correct? State's Exhibit 1 tendered into evidence without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. Is that true? Yes. State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived?
Yes, Your Honor.
Sir, I'm going to follow this agreement. If nothing further, I'm going to find you, Joshua Booker, are pleading guilty to this aggravated sexual assault of a child as indicted in 23 CR 1490. You were doing this voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this offense. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 45 years. Do you understand what has happened today, sir? And you will be given credit for all time that you have served in connection with this offense up to now. Anything else?
And Your Honor, just after the victim would like to give an allocution.
Okay.
And one more thing from the defense, Your Honor.
Yes, sir. Go
During
ahead.
the pendency of this case, Mr. Booker's ability to communicate with the outside world was restricted due to some statements that were made to Paige Davis, who is not one of the is not the victim or the victim's mother or anything of that nature in this case. We'd ask that those restrictions be lifted. Ms. Davis is here to provide some testimony if the court would like to hear it.
Okay. You're asking me to
allow him to communicate.
It's up. I think that's up to the jail.
Well, this is.
You know, he said I made a ruling. I made a ruling on this earlier.
That's correct, Your
I
Honor.
have to review it. But
Yes, sir.
Is there any objection to what
There's
he
no
said?
objection, Your Honor.
Okay. I don't have a problem with allowing that, and we'll get that information over to the jail. You just obviously have to be careful what you say in all conversations. Can't be threatening, and it can't be vulgar. And all right. Anything else on this?
Just the allocution.
All right, we're going to go dark. Caleb Landry, please. Mr. Landry. We start off, we've got two cases, correct?
Correct, Your Honor. Both.
And you are Caleb Landry?
Sir.
In 23 CR 908, the earlier case, you were charged with the state jail felony of burglary of a habitation on or about February 14th, 2023. And that carries with it no less than 180 days up to 2 years in the state jail. You'll understand if convicted.
I think you said burglary of a habitation.
I said burglary of a building, state jail, a burglary of a building, not a habitation, a burglary of a building, which is lesser than a burglary of a habitation. It's no less than 180 days up to 2 years in the state jail. Burglary of habitation is a second degree felony. Do you understand what you're charged with here in this?
Yes.
And in 24 CR 2225, filed on October 23rd of last year, this states that on September 17th, 2024, that you committed the state jail felony of burglary of a building Looks like the same building owner. The victim is the same as the
It's,
previous case.
Probably discount tires, I think.
And it goes on to state that you have, in this indictment, you've been convicted in 2005, felony offense of illegal possession of marijuana, a state jail felony out of Harris County, Texas. And in 2015, you were finally convicted in the criminal district court here of delivery of marijuana. And that doesn't affect the punishment range on this, does it?
Yes, Judge, if he's
Two prior state jail felonies on separate.
Makes it a third.
Makes it a third
So,
degree.
well, your punishment range is in two things that are problematic. Your punishment range will be enhanced if this is proven true to what would be a third degree felony punishment. It's state jail felony, but it's punished as though it was a third degree felony under law. And you were looking therefore at no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Plus, if this is true, you are not eligible for probation in either of these cases. Do you understand?
Sure.
Okay, that's should be a lot on your mind here. What are we going to do today?
You know, the state has tendered an offer of 12 months or 1 year in the state jail facility. And
how much time does he have credit, if any? Please. Okay, go ahead.
And Mr. Landry's advised that he's refusing that. Is that correct?
Okay.
That's
what you want to do?
State's offer.
That's what you want to do?
Because
It's a hard decisions, but it's your life. Right now, we're at a crossroads. It's either going to go that way or this way. Which one?
To be clear, one thing that hasn't been stated, he is not eligible to receive probation from a jury.
I said that.
Should he do that, I will, if he continues down that path, I'll withdraw the state jail offer and give the enhancement notice on both cases so that they're both dealing with third degree. Sure.
Okay, it wasn't.
It wasn't included in the first indictment for some reason. We must have recovered them by the time he alleged to have committed the second offense.
He has 17 days credit.
Okay, not a lot.
Not a lot.
Let me ask something here. What's his bond?
What are your bonds?
$5,000
each. They were probably 5 each or where I would have. That's what he seems to.
He's correct.
Okay. When was this bond posted? In 908. I'm looking at July 15th of 2024, correct? Is that right, everybody? That's what I'm seeing.
If that's right, then
it's $5,000.
He's alleged to have committed the second offense while he was
in
on
September.
bond.
Yeah, we got a bond issue. You committed, according to the grand jury, and this second offense after you had been charged and in this earlier case, and you posted a bond of $5,000. Looks like the amount of bond was fixed at $25,000 on July. I'm looking at another document that says July 20th.
He made the accusation that run the initial arraignment may have been 20.
There's a 715, a $5,000 on 7 that he paid on 7/15. But then there's a warrant for an arrest, a capious burglary of a building filed on July 16th. Okay. And the bond was fixed.
He probably got
Says the amount of bond fixed by the court in this case is $25,000 here.
That was probably the initial arraignment. He didn't postpone.
Yeah, it was an arraignment.
And he got out on accusation after that, and the warrant popped up sometime after he was released on accusation in the bond.
But it's showing 5,000. Is that right, Lacey? It's showing 5,000 on this. Okay.
But he was arrested on.
And all of this was done though before it is alleged that he commits this next crime, 24 CR 2225.
He may have been out on the accusation on the second offense.
The second offense is on or about September 17th of 2024. All of this is July. And July.
Which the initial bond he made in 908 was made on 7/15 of 24,
Yes. Of,
$5,000.
yes. Then what?
And then it looks like. Looks like the bondsman surrendered that bond when he was rearrested. And he made another bond. In this case on 2/10 of 25.
Of how much?
The initial bond was.
No, I'm talking about the new bond.
She didn't care if there was an airport for those.
It wasn't an AFR, so it was a surrender.
Oh, all right.
Is it showing it's still 5,000? Yes.
Yes,
Okay.
still 5,000.
Okay. And then when did he post the bond in 24, 22, 25? The new thing.
10 of 25,
What was that bond?
5,000.
Yes. Well. On what day now?
2/10 of 25.
Okay.
That's after the.
Mhm. Yeah, that indictment had already been prepared and has those prior convictions, and then you have that.
Right.
It just slipped. It must have slipped by somebody. See, on this indictment, here's what's, once again, I don't know how this is happening. On this indictment, on the face of the indictment, 7/20/23, that's me writing it. When I get the bond, I'm setting the bond at $25,000 plus a GPS device. Do you even have a GPS device? You don't even have that. I don't know what are my orders doing here that aren't being followed. I don't understand. But this was my orders on July 20th of 2023. Thereafter, those are changed. Or
I represent the court. I didn't have anything to do.
you didn't. Yeah, you're always the first suspect, but you've been cleared in this
I would
one.
like to take credit.
Anyway,
I don't have any notes to explain, Judge.
those were being changed without, and this court had authority over this case, and somebody else was changing these.
It was post indictment.
It was post indictment after I had signed these orders, which are equivalent to an order, which is inappropriate, but we'll figure it out. Anyway, this court doesn't find $5,000. I mean, I put $25,000 up here, but I did this before this indictment shows up.
Right.
And then this indictment shows up, another burglary of a building, which is alleged to have occurred on or about September 17th of 2024, after he was on bond here. Your bond's $100,000 in each case. Plus, you have to have a GPS device as a condition of bond. So this is irresponsible and of your part. And once you are charged with a crime and a bond is set, and you're presumed innocent unless found guilty. But these are probable cause decisions by the grand jury that you probably committed these crimes, which are what we base bonds on, as the probability a crime has been committed. And we use the circumstances of the case and the criminal history. Your first bond of $5,000 is the same type of offense that you post a bond. A few months later, you're committing another of the same offense, the same type of offense, as though none of this mattered to you. You weren't taking it seriously. You are now. We're going to take it seriously. You can't just keep committing crimes and think that you can just pay a small bond and not that additional information and additional crime commission won't have a bearing on it. It does. So those are the orders. You must have a GPS device, and the bonds are amended to $100,000 each because of your criminal history and the fact that you're committing the same crime after you posted a bond in the first case of a similar matter. Just a few months after that, you're committing the same kind of crime, according to the grand jury. Anyway, That's the orders of the court. Next event, you set these for trial? It'll be set for trial. Thank you. That's what we'll do. 24 CR 1593 is called the State of Texas versus Perry Ashworth. Mr. Ashworth is present with his attorney, Mr. Kimler, and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
You guys, just to be clear, for the more than Mr. Ashworth has a prosthetic leg that his leg was amputated in an occupational accident years training, so that's why it's illegal.
That's okay. Okay. He actually is standing more upright than a lot of the folks who are healthy stand. I hate to say, but he's doing, I appreciate him. Okay. In summary, sir, this indictment alleges in paragraph 1 that on or about January 10th, 2023 in Jefferson County, Texas, you committed the offense of operating a motor vehicle in a public place while intoxicated. Now, that would be otherwise a misdemeanor, except this indictment goes to allege you have 2 or more prior convictions, which then make it a felony. And it states in November of 2020, you were convicted twice out of County Court at Law number 2 of Jefferson County for DWIs, operating motor vehicles while intoxicated. So paragraphs 1 and 2 then therefore together constitute a 3rd-degree felony. And that means that you are facing no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand all of that?
Interesting.
Yes. An agreement's been reached where you would be pleading guilty to paragraphs 1 and 2, this 3rd-degree felony. Found guilty, sentenced to imprisonment for 5 years. That would be suspended. You would be placed on regular probation for 10 years. There would be terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty to this indictment voluntarily and because it is true as it is alleged?
Yes, sir.
And these 2 prior convictions in 2020 of DWIs in paragraph 2 in this indictment, are those allegations true and correct as they are alleged? And are you pleading true and correct to that voluntarily?
Sir.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. Then that's a guilty plea, paragraph 1, true to paragraph 2, constituting its 3rd-degree felony, operating a motor vehicle while intoxicated on a public place. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Is the pre-sentence report waived?
So, ladies, Your Honor, I think as far as I would anticipate on the 10 days jail time, Mr. Ashworth would request that he'd be allowed to do that on the weekends, not go into custody today.
Okay.
I don't have a problem with that.
If anything,
And the reason for that is,
That's okay.
again, the prosthesis.
That's okay. Actually,
it's problematic with extended
Yeah.
stays. So
It's kind of, you can do that. And I always allow people, if they want to do it on weekends, but I'll tell you what is said to me is when they go in and they go on weekends, by that second weekend, often I hear them say, can you just convert it to straight time? Because you've got that gap. You can do whatever you want, but I'll defer it to people. If they want to, if they can, a lot of people need to work during the weekday, for instance, and I work with them, but they'll say, you get out on Sunday, you have to go in by 6 o'clock Friday. They release you at 6 p.m. Sunday, and then you're looking forward to next Friday until it's over with. And some people have that. That's hard to bear. But we'll work this out for you. I'm going to find you were pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this third-degree felony. I now find you guilty beyond a reasonable doubt here. I'm following this agreement. You are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 5 years. That is suspended. You are placed on regular probation for 10 years, and there will be terms and conditions of probation here that are being prepared by the probation office, which are normal and customary for this. Make sure you follow it. If you fail, your probation can be revoked and you can be sentenced no less than 2, no more than 5 years in prison. Also, when do you start your jail time? This Friday?
Next Friday.
Your Friday week? Okay,
Yeah,
that's good.
that'd be-
Friday
that'd
week
be time
on the 27th. Yes, sir. On or before 6 o'clock PM. And you'll do it 5 consecutive
Yes, sir.
weekends.
And if you don't, then that can be the reason that your probation is not.
Okay. Probation. But the initial term, is transferred.
Thank you so much.
Let's talk to him.
Thank you.
Thank you.
Thank you, Judge.